If I may, I wanted to respond to some of the commentary that's been made regarding originalism, sometimes described as constitutionalism. It's not a doctrine that I happen to agree with, and I think too often it's a foil for just living in the past substantively. But I at least admire those who have the courage of their convictions on originalism. And I note that Justice Scalia, who was a self-described originalist, in the matter of public disclosure of financing and funding for organizations, took the originalist point of view and referred to what he called the century-old practice of states prohibiting anonymous electioneering, and contrasted that with the many centuries-old practice of public legislating and voting, and came to the conclusion that an originalist determination, a textualist determination, meant that requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed, and that anonymous campaigns hidden from public scrutiny and protected from the accountability of criticism were not consistent with those principles. Scroll forward to Americans for Prosperity Foundation, the case that just came down from the Supreme Court on a partisan 6-3. Americans for Prosperity Foundation is a big dark money group that is at the center of the Koch brothers' political manipulation and mischief, if you don't mind me saying so, enterprise. The AFPF decision completely ignores what Justice Scalia said in Doe versus Reed. It is not textualist. It is not originalist. And it relies on appellate fact-finding. Appellate courts aren't supposed to do fact-finding, but we constantly see appellate fact-finding by the Supreme Court in politically charged cases. So the politically charged the fact-finding in this politically charged case was all about the risks of threat and harassment, on which there was no record. The Supreme Court judges just went off willy-nilly, fact-finding their way through this without the discipline of a proper record and proper review, just as they did in Citizens United, where they engaged in completely flagrant and unsupported fact-finding about the independence and the transparency of the unlimited political funding that they were unleashing, which has been proven just indisputably wrong in the decades since then, which they've conspicuously refused to correct, just like they did in Shelby County, where they made fact-finding unsupported by any record about a new age in the states that had a long record of voter suppression, that there wouldn't be voter suppression any longer, totally belied by the cases that followed, finding surgical precision in the targeting of minorities for voter suppression. So over and over again, we hear talk from our friends on the other side about originalism and textualism. Over and over again, you see a court whose nominal originalists and textualists will jettison those principles when they interfere with the outcome that they seek. I wrote a piece a long time ago, published by the American Constitution Society, with a whole appendix that lays out the repeated cases in which the so-called conservative doctrines were ignored or jettisoned by the so-called conservative judges where they didn't align with the outcome that the judges wanted. It calls to mind Justice Cardozo's famous remark that a judge is not supposed to be a knight errant, roaming at will in pursuit of his own ideal of beauty and goodness. The difference is, with Justice Cardozo, at least in that example, he was talking about the judge's own ideal of beauty or goodness. What we're dealing with here is judges who are implementing a dark money enterprises ideal. And we see it right in that Americans for Prosperity Foundation case, because even at the certiorari proceeding stage, 50 right-wing dark money groups came to tell the court what they wanted. 50. Usually they come in little flotillas of about a dozen. 50 was a clarion call to the conservative judges, this is what we want, you're supposed to deliver. And deliver they did, but don't tell me it's textualist, don't tell me it's originalist, and don't tell me it's appropriate for the Supreme Court to engage in spontaneous, willy-nilly fact-finding unmoored from the discipline of a record and of facts found by courts below. It just isn't the way this process is supposed to work. I have similar thoughts about the Brnovich case, but I would simply adopt and endorse the comments Senator Padilla made about that case, which I thought were very strong. It invented extra-textual guidelines that are not in the Voting Rights Act, that are not in the Constitution. The judge who authored that opinion even put in Republican talking points on voter fraud that, when they're actually tested, prove to be without factual justification. The idea that a judge is not only fact-finding, but fact-finding Republican talking points that are not supported in real life is, I think, a new low in judicial fact-finding. So I'll go with Judge Kagan's dissent, which I think accurately said about Brnovich, the majority's opinion mostly inhabits a law-free zone, but it got them the outcome they wanted. In AFPF, they got a new home for dark money in the United States Constitution, unprecedented, no basis for it in the Constitution whatsoever. And in Brnovich, they kicked a new hole in the Voting Rights Act, like the Shelby County hole that they kicked, just at the exact moment that the entire Republican Party has swiveled under dark money pressure into voter suppression as its tactic for winning in 2022. And that's not me saying that, that's Heritage Action saying that through a leaked video in which the Heritage Action person confessed that they had driven all of this activity in the states that were driving it, that they had written many of the laws that were being pushed in those states without the legislators even knowing it was them, that they had used what she called sentinels to be their intermediaries to get this dirty work done. That's the context in which the Supreme Court, at least the Republican judges on the Supreme Court, rendered the Brnovich decision without textual support, without statutory support, without originalist support, with completely improper fact-finding. So I'm a little, I've had it a bit with this selective originalism and selective textualism. If they're going to be your doctrines and if they're going to be your principles, fine. Live by them. But don't jettison them as soon as they lead you to a result that the big dark money apparatus that has made this the court that dark money built desires. Thank you, Chairman.
Mr. Chairman.